Okay, so today we're going to dive deep into a couple of legal concepts you'll often find intertwined with financial and contractual agreements.
All right.
We're talking about cesión de créditos, which is assignment of credits, and subrogation.
Yeah.
And our primary source for this deep dive comes from a multidisciplinary law firm in Spain called MCHM Abogados.
Okay.
Now they're based in Almeria, and they serve individuals, companies, and even public entities across the whole country.
Yeah, it seems like they have a pretty good grasp on how these things work in the real world.
Exactly. And what's interesting is they list out all these areas of law they specialize in on their website, and it's quite extensive.
Oh, really? Like what kind of stuff?
Like they handle everything from, inheritance law to intellectual property, even criminal law.
Wow, that's a pretty broad range.
It is, yeah. So you can kind of get a sense of, they've probably dealt with these concepts of cesión de créditos and subrogation in all sorts of different contexts.
Right, yeah, because, those concepts apply to a lot more than just, simple loans.
Absolutely.
They come up in all kinds of financial agreements and contracts.
Right. So I think having that broad perspective is going to be really helpful for us today.
Yeah, definitely.
So for anyone looking to get in touch with MCHM Abogados, their main office is located at Calle Santiago Vergara 20 in Almeria.
Okay.
Their phone number is 950-106-453. And they also have an emergency line, which is 674-21-6559.
Good to know.
And, of course, they have an email address. It's info@msmabogados.as.
Gotcha.
And they're open Monday through Thursday from 8:00 a.m. to 7:00 p.m. And then on Fridays, they're open 8:00 to 3:00 p.m.
Perfect standard business hours.
So, yeah, if you're ever in need of legal assistance in Spain, those guys seem like a good resource to have.
Absolutely.
So let's dive in. What we really want to do today is give you a clear understanding of how both cesión de créditos and subrogation work.
Right.
We'll break down their characteristics, how they differ and what their practical implications are.
Exactly. And I think it's important to address right away that these two terms can be confusing because they both involve transferring something within a financial or contractual agreement.
Right.
But they do it in fundamentally different ways and have different impacts on the parties involved.
Yes, absolutely. So let's start with cesión de créditos, or assignment of credits, as we said.
Okay.
Can you give us a simple explanation of what that means?
Sure. So cesión de créditos basically means the transfer of a credit from one person to another.
Okay.
So imagine you're owed money by someone, right?
Okay.
You have a credit.
Right.
Now you can transfer that right to receive that money to someone else.
Gotcha.
And that's what cesión de crédito is all about.
So I become what's the term?
You would be the cedent.
Cedent.
Yeah, you're the original creditor.
Okay.
And the person you're transferring the credit to, that's the cessionary.
Okay, so I'm the cedent.
You got it.
The new person's the cessionary.
Yes.
And the person who owes the money is just still the debtor.
That's right. The debtor stays the same.
Okay.
It's just the creditor that changes.
Gotcha. And this transfer can be done for free or for a payment, right?
Exactly. So it can be a titolo gratuito, which means free of charge, like a gift or donation.
Yeah.
Or it can be a titolo oneroso, which means for a price like a sale.
Oh, okay. So there's actually a couple of different ways this can happen.
Yeah, there are. And the specific circumstances of the transfer will obviously have an impact on things like, tax implications or how the credit is valued.
Right. Yeah, that makes sense.
But regardless of how the transfer happens, the key thing to understand is that the cessionary basically steps into the shoes of the cedent.
Okay.
They take over all the rights associated with that credit.
So it's a total transfer.
It is, yeah. They get all the rights to demand payment from the debtor, to negotiate payment terms within certain legal limits.
Wow.
And generally act as the new creditor.
So I'm completely out of the picture then.
Essentially, yes. Once you transfer that credit, you're generally no longer involved in that specific debt.
Huh.
Your relationship with the debtor regarding that particular credit is over.
Interesting. So it's a clean break for me as the original lender?
Yeah, you could say that.
But there are legal requirements that need to be met for this to be valid, right?
Oh, absolutely.
Yeah.
Yeah, it's not just a handshake deal.
Right.
There are certain legal formalities that need to be followed.
Okay, so what are some of the key things our listeners should be aware of here?
Well, first and foremost, both the cedent and the cessionary need to have the legal capacity to enter into this kind of agreement.
Right. They have to be legally allowed to do this.
Exactly.
Okay.
And beyond that, one of the most important requirements is that the debtor needs to be notified about the assignment.
Oh, that makes sense.
Yeah, they need to know who they're supposed to pay now.
Right, because otherwise they might keep paying me.
Exactly. And that could create all sorts of problems for the cessionary.
Yeah. Legal headaches for everybody.
For sure. And depending on the specific type of credit being assigned, there might also be specific requirements regarding the documentation of the transfer,
Oh, okay.
to make sure it's legally sound and enforceable against third parties.
Right. So it has to be official.
Exactly.
So let's get into some practical examples to help our listeners really grasp this.
Okay.
Where do we actually see cesión de créditos in action in the real world?
Well, one very common example is in the context of purchase agreements.
Okay.
Let's say you buy something online and you choose a buy now, pay later option.
Right.
The retailer might then sell that receivable, which is your future payment obligation, to a financing company.
Okay.
So the financing company becomes the cessionary.
Right. The one I'm now paying.
Exactly.
Gotcha.
This allows the retailer to get their money up front, and the financing company takes on the risk and responsibility of collecting the debt from you.
Interesting.
Another common scenario is when banks or financial institutions sell portfolios of loans to other institutions or debt buyers.
Okay.
This is often done to improve their balance sheet ratios or to offload debts that are becoming difficult to collect.
So it's a way for them to manage their risk and free up capital.
Exactly.
And in those cases, the debt buyer becomes the new creditor, the cessionary.
That's right.
So that's kind of where we see those debt collection agencies coming in, right?
Yeah, that's a good example. They've essentially bought the right to pursue those old debts.
Okay, so that's cesión de créditos.
Right.
Now let's move on to subrogation, which, as we said, is a bit different.
Yeah, it is.
Can you explain how subrogation differs from just assigning the right to receive payment like in cesión de créditos?
Sure. So with subrogation, we're not just transferring a specific right.
Okay.
We're actually substituting one party for another within an existing contractual relationship.
Interesting. So it's more like I'm stepping into someone else's shoes completely.
Exactly. It's a complete substitution.
Okay.
So in the context of debt, this means that a third party called the subrogated party takes the place of the original debtor, the subrogator,
Okay.
and they assume all the rights and obligations of that original debtor under the contract.
So it's not just about the debt itself, it's about the entire agreement.
Exactly. The whole contract comes into play.
Gotcha. And the source material talks about two types of subrogation. Right.
Subrogation legal and subrogation conventional.
Yes.
Let's unpack that. What's subrogation legal?
Subrogation legal is when the subrogation happens automatically by law.
Okay.
It's not something the parties have to agree to. It's just dictated by the legal framework.
Interesting. And what's an example of that?
A good example is life insurance.
Okay.
When the insured person passes away, the beneficiary of the policy steps into the shoes of the deceased insured in relation to the insurance company.
So they inherit the rights and obligations of the policy.
Exactly. They acquire the right to claim the death benefit, for example.
Right.
But they also take on any obligations that were associated with the policy.
Okay, so it's a complete substitution dictated by law.
Precisely.
And what about subrogation conventional then?
So subrogation conventional is based on an agreement between the parties involved.
Okay, so it's voluntary.
Exactly. It's a deliberate choice.
And can you give us an example of that?
Sure. Let's say someone is struggling to repay a loan.
And a family member agrees to take over the debt,
Yeah.
with the consent of the lender, of course.
Right.
This family member would become the new debtor, the subrogated party.
Okay.
And they would be responsible for repaying the loan under the original terms.
So it's like a refinancing, but with a new person involved.
Yeah, you could think of it that way.
So to recap, subrogation legal is imposed by law.
Right.
And subrogation conventional is based on an agreement.
Exactly.
Okay, now what are some of the key characteristics of subrogation in general that our listeners should remember?
Well, the most important thing to keep in mind is that the subrogated party takes on all the responsibilities of the original debtor.
Okay.
They step into their shoes completely.
So all the obligations of the original contract are transferred to them.
Exactly. They are now fully responsible.
And what about the rights of the original debtor? Do those get transferred too?
Yes, they do. The subrogated party also acquires any rights the original debtor had under the contract.
Okay, so it's a two-way street.
It is, yeah. It's
Yeah.
a complete transfer.
Gotcha. And another key point that the source material highlights is that the original contractual relationship continues.
Yes, that's a crucial point.
It's not a brand new contract. It's the same contract with a new player.
Exactly. The subrogated party simply steps into the existing agreement.
Okay, and this is a major difference from cesión de créditos, right?
Absolutely, because in cesión de créditos, the original creditor is usually out of the picture completely.
Right, they just transfer the right to receive payment and they're done.
Exactly.
But with subrogation, the original creditor is still involved.
Yes, their rights remain, but they're now directed toward the subrogated party.
Okay, so that's a very important distinction.
It is. Yeah, it's one of the key differences between these two concepts.
Okay, great. So let's really hammer home those key differences between cesión de créditos and subrogation.
All right.
How can our listeners keep these two concepts straight in their minds?
Well, one way to think about it is to focus on the relationships created by each mechanism. In cesión de créditos, the original creditor forms a new and separate relationship with the cessionary, the new creditor.
Right.
And their relationship with the debtor is over.
So the original creditor is gone from the original agreement.
Exactly.
Okay.
But in subrogation, the subrogated party steps directly into the shoes of the original debtor within the existing contractual relationship with the creditor.
Right.
So the original debtor is the one who's exiting the original agreement.
Okay, so in cesión de créditos, it's the lender who leaves.
Yes.
And in subrogation, it's the borrower who leaves.
Precisely.
Gotcha, that's helpful. Another key difference seems to be the role of the debtor.
Yes, that's another important point.
In cesión de créditos, the debtor needs to be notified about the assignment.
Right.
And sometimes their consent might even be required.
Exactly. It depends on the specific situation.
Okay.
But with subrogation legal, the substitution can happen automatically by law without the debtor's consent. And even with subrogation conventional, while the debtor is usually involved in the discussions, their explicit consent to the subrogation itself isn't always a strict legal requirement.
Oh, okay. So the debtor has less say in subrogation than in cesión de créditos.
Generally speaking, yes.
Gotcha. And finally, let's just reiterate what exactly is being transferred in each case.
Okay, so in cesión de créditos, what's being transferred is the right to receive something, typically payment.
Okay.
It's like selling an IOU.
Right.
But in subrogation, what's being transferred is a position within a contractual obligation.
Okay.
Someone else is taking over the responsibilities and duties that were originally held by one of the parties.
So it's like taking over someone's job.
Yeah, that's a good analogy.
So to sum it all up, cesión de créditos is about transferring the right to get paid.
Yes.
And subrogation is about someone else stepping in to fulfill existing obligations.
Exactly.
Okay, so as we reach our conclusion, it seems like both cesión de créditos and subrogations are valuable tools for managing financial and contractual situations.
They are definitely.
They provide flexibility and options for both individuals and businesses.
Absolutely.
And as MCHM Abogados points out, the choice between these two depends on the specific circumstances and the goals of the parties involved.
Exactly. There's no one-size-fits-all solution.
Right. So it's important to seek professional advice.
Absolutely.
Yeah.
Especially from a lawyer who specializes in this area.
Yes, they can help you understand the legal implications and make the best decision.
Exactly. And, MCHM Abogados, with their extensive experience, could be a great resource for anyone dealing with these issues in Spain.
Definitely, their contact information is readily available on their website, and they seem to be well-equipped to handle all sorts of legal matters.
For sure.
So for our listeners out there, as you continue to explore these concepts, we'll leave you with one final thought to ponder.
Okay.
Imagine you're the original creditor in a situation where the debtor is struggling to fulfill their obligations.
Okay.
Would you prefer to pursue a cesión de créditos to get your money back quickly? Or would you be open to allowing a subrogation of the debtor potentially with someone who's more financially stable?
It's interesting.
What factors would you consider in making that decision?
Yeah. That's a great question to think about.
It really highlights the different implications of these two legal mechanisms.
It does.
So yeah, thanks for joining us for this deep dive into the world of cesión de créditos and subrogación.
My pleasure.
We hope you found it informative and engaging.
Absolutely.
And remember to always seek expert advice when dealing with complex legal matters.
Always a good idea.
Until next time.
See ya.
Bye.